Every single day, you exercise rights you did not earn, you did not fight for, and you probably cannot name the case that gave them to you. And that is not a criticism. It is just the truth. The legal ground beneath your feet was poured by judges, lawyers, and ordinary people who ended up in the wrong place at the wrong time and changed everything. We are talking about courtroom decisions made decades, sometimes over a century ago, that still shape what police can say to you, what corporations can do to your data, what a hospital must tell you before surgery, and whether you can be fired for something you posted online last Tuesday. These cases are not dusty footnotes. They are the invisible architecture of your daily life. In the next 10 minutes, you will learn exactly which landmark precedents still govern your most ordinary interactions, why some of them were decided by the slimmest possible margins, and the one ruling that legal scholars argue was decided completely wrong yet somehow produced the right outcome for millions of Americans. That last one is going to make you think twice about how justice actually works. To understand why these precedents carry so much weight, you need to understand how the American legal system operates. The United States follows a doctrine called stare decisis, which is a Latin phrase meaning to stand by things already decided. When a court, especially the Supreme Court, issues a ruling, that ruling becomes binding precedent. Lower courts must follow it. Future cases must be measured against it. It is not a suggestion. It is law by another name. This system creates a kind of legal inheritance. Every generation inherits the decisions of previous ones, for better or worse. And because the Supreme Court takes fewer than 100 cases per year from the thousands submitted, each decision carries enormous weight. One morning in Washington can rewrite the rules for 330 million people. The first precedent you need to know is Miranda versus Arizona, decided in 1966. Ernesto Miranda was a 23-year-old man arrested in Phoenix on charges of kidnapping and rape. He was interrogated for 2 hours without being told he had the right to remain silent or the right to an attorney. He confessed. He was convicted. And then the Supreme Court threw it out. Chief Justice Earl Warren wrote for the majority that the prosecution cannot use statements made during a custodial interrogation unless the suspect was first informed of their Fifth Amendment rights. You know the words. You have heard them on every crime drama ever made. But here is what nobody talks about. Miranda himself was retried, convicted again using other evidence, and later paroled. He was eventually stabbed to death in a bar fight in 1976. The man whose name you know better than most presidents never personally benefited from the ruling that bears his name. What Miranda gives you today is a procedural shield. If you are ever arrested and questioned without being Mirandized, any statement you make during that interrogation can potentially be excluded from trial. That one procedural requirement has shaped tens of thousands of criminal cases in the decades since. The second landmark you live under every day is Roe versus Wade, or more accurately now, its reversal in Dobbs versus Jackson Women's Health Organization in 2022. But understanding Roe matters because it illustrates how precedent can stand for nearly 50 years, affect millions of lives, reshape political parties, and then be overturned in a single decision. Roe established in 1973 a constitutional right to abortion based on a right to privacy found in the 14th Amendment. Dobbs removed that federal protection entirely, returning the question to individual states. The point here is not political. The point is that no precedent is permanent. Every right you hold based on a Supreme Court ruling exists only as long as that court is willing to uphold it. Now consider Griswold versus Connecticut from 1965. This case struck down a state law banning married couples from using contraception. The Supreme Court found that the Constitution contains implied rights not explicitly stated in the text, specifically a right to privacy. That logic became the foundation for Roe, for Lawrence versus Texas, which decriminalized same-sex relationships, and for Obergefell versus Hodges, which legalized same-sex marriage nationwide. Pull one thread and the whole fabric shifts. But here is what nobody talks about when it comes to privacy law. The most consequential privacy decision affecting you right now was not about marriage or contraception. It was about a man named Katz. In Katz versus United States, decided in 1967, federal agents had bugged a public phone booth to record Charles Katz placing illegal bets. No physical trespass, no warrant. The Supreme Court ruled that the Fourth Amendment protects people, not places. If you have a reasonable expectation of privacy, the government needs a warrant to intrude. This case gave birth to the concept that redefined surveillance law for the next 60 years. Every question today about whether law enforcement can access your cell phone location data, your emails, your smart home device recordings, every single one of those arguments traces back to that phone booth in Los Angeles. The CAT's reasonable expectation standard is the legal framework courts use to decide what surveillance is constitutional. And in an era of facial recognition software and always-on microphones, the stakes of that 1967 decision have never been higher. Next comes Palsgraf versus Long Island Railroad, a torts case from 1928 that most non-lawyers have never heard of, but that governs almost every personal injury lawsuit ever filed. Here is what happened. A railroad employee helped a passenger board a moving train. The passenger dropped a package of fireworks. The fireworks exploded. The blast knocked over scales at the other end of the platform, which fell on a woman named Helen Palsgraf. She sued the railroad for negligence. The New York Court of Appeals, in a decision written by Judge Benjamin Cardozo, ruled that you can only be held liable for harm that was reasonably foreseeable to someone in your position. The railroad could not have foreseen that helping one passenger would injure a woman standing far away. That concept, proximate cause, is the reason corporations, drivers, doctors, and property owners are not automatically liable for every bad outcome connected to their actions. It is the legal break on unlimited liability. Without Palsgraf, you could theoretically sue almost anyone for almost anything. With it, courts ask whether the harm was a predictable consequence of the defendant's conduct. Think about how this affects you right now. If you slip on ice outside a store, the store's liability depends on whether it reasonably could have foreseen that condition causing harm. If a product malfunctions and injures you, the manufacturer is liable only for harms a reasonable designer should have anticipated. Palsgraf is everywhere. Brown v. Board of Education from 1954 needs no lengthy introduction, but its legal legacy goes far beyond school desegregation. Chief Justice Earl Warren's unanimous decision declared that separate educational facilities are inherently unequal, overturning Plessy v. Ferguson, which had stood since 1896. The legal mechanism used in Brown, a finding that a law causes psychological and social harm even without overt physical deprivation, became a template for challenging discriminatory laws across American life. Employment law, housing law, voting rights law all drew from the reasoning in Brown. What people do not always recognize is that Brown did not desegregate schools overnight. Implementation battles lasted decades. But as legal precedent, it permanently closed the door on the separate but equal doctrine and established that courts could look beyond formal legal equality to examine real-world impact. The final precedent worth understanding is Citizens United v. FEC from 2010, in which the Supreme Court ruled that corporations and other outside groups have a First Amendment right to spend unlimited money on political advertising. Whether you celebrate or despise that ruling, it fundamentally altered American elections. Political spending from outside groups has increased by hundreds of millions of dollars per election cycle since that decision. The ads you see, the mailers in your mailbox, the digital targeting you experience during election seasons, all of it flows from that one ruling. These cases represent something bigger than legal trivia. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Eagle Brief for a brand new video every single day. We will see you in the next one.